Hi, and welcome to our presentation of developments in key issues for health and welfare plans in 2020, which is the last in a series of programs from our Benefits and Compensation University for 2020. I'm Debbie Hoffman. I'm a benefits lawyer in the Chicago office of Mayor Brown, and I'm joined by my co-panelists, Karen Grotberg and Stephanie Vasconcelos, who are also benefits lawyers in our Chicago office. Before we get started, I have some administrative things to go over, and I'm going to read them to you so that I don't screw anything up, because I will be saying the word widgets. And when I was in law school, widgets was a pretend thing that we used as a something to talk about if we didn't really know what we were talking about. And now I understand they're real things, so I don't want to lead you in the wrong direction. First, at the bottom of your screen, you will notice there are multiple application widgets you can use, including the question and answer widget for those of you who have questions. Answers to some common technical issues are on the help widget on the right. For the best viewing experience, we recommend using a wired internet connection, preferably with Chrome or Firefox browsers, and closing any programs or sessions running in the background that could cause issues. Some networks cause slides to advance more slowly than others, so logging off of your VPN or Citrix may also help. If you are applying for CLE credit, you will need to record the alphanumeric codes provided during the program on the affirmation form found on the resource widget. There will be two codes provided, one about halfway through the program and the second at the end. Also in the resource widget you will find links to today's slide presentation, speaker bios, and evaluation forms. Please complete the evaluation forms, as it will help to make sure that we provide the content that you want and help us to provide better presentations to you. The webinar is being recorded, as we normally do with these programs. In a day or so, we'll be sending you an email link so you can listen to the webinar again or share it with your colleagues. And the recording will also be posted on our website. Finally, we hope to allow time at the end for questions and answers. To submit a question electronically, please use the Q&A widget. If we don't get to answer your question during the webinar, we will make every attempt to follow up with you afterwards. That's the end of the reading for the day. Before we get into the actual presentation and discussion of the issues, since this is a presentation on health and welfare plans, we didn't want to let the opportunity pass to wish the Affordable Care Act a belated happy birthday. It reached 10 years old in March of this year, and we're still fighting about it as a nation. As you probably know, in a couple weeks, there's going to be Supreme Court arguments on the constitutionality of the Affordable Care Act, and Stephanie's going to be discussing some of the procedural aspects of that later in the presentation. But before we get into that part of the presentation, I thought that it might be helpful to kind of just talk about what could happen with this case. You know, Stephanie, I understand that this is a constitutional challenge to the Affordable Care Act based on the fact that it was previously supported because the individual mandate was treated as a tax. And in 2017, the Tax Reform Act repealed the penalty or tax on the individual mandate. And now the challenge is that because that tax was repealed, the individual mandate, and in fact, the entire Affordable Care Act, is unconstitutional. And the other weird thing about this is that the case was brought by the Republican attorney generals and is being defended by Democratic attorney generals, which is an odd construct. And given the current state of affairs with the Supreme Court and their rulings in prior situations with the Affordable Care Act and what they've said that they think about interpretation of provisions of law, whether it craters the entire law or just that provision, what do you think is going to happen?
Well, you know, those are good questions, and they may require me to be more of a fortune teller than I am. But you absolutely have that right. And I know I won't be the only one listening really closely to the oral arguments that are scheduled for November 10th. There are several possible outcomes, some of which may mean there are no real structural changes to what we see today with the Affordable Care Act. One, of course, is that the Supreme Court may not actually get to the substance of the case. It may be that they determine that the plaintiffs in the case don't actually even have standing to bring the case. Assuming they actually to the substance of the issues, one possible outcome is that they actually uphold the individual mandate as constitutional, even though there's no longer a tax associated with it. That may be a stretch, given that there were only 5 justices that supported it as a tax originally. But if that's the case, nothing should change from the world as we know it. The next option is that they may find that the individual mandate itself is not constitutional, but it can be severed or separated from the remainder of the Affordable Care Act. And if that's the case, then we really shouldn't see a difference. I mean, right now, the individual mandate, because it comes with a $0 penalty, doesn't really have any teeth. So I don't think that any individuals or employers will see a difference on a day-to-day basis. The real change will come if the court finds that the individual mandate isn't constitutional and it can't be severed from the Affordable Care Act, because it's so fundamental to the principles of the Affordable Care Act that it just can't be separated from it. And this could be catastrophic to the system as we know it. Part of the Affordable Care Act are the health insurance exchanges, the prohibitions on pre-existing condition limitations, annual limits and lifetime limits, things that people have come to know and rely on in their health plans over the last 10 years. Of course, if we have a new administration, this result could be avoided if they simply reimposed a penalty in connection with the individual mandate. All that, and we don't even know the full identity of the court that will be hearing the case on November 10th. So there's a lot of speculation that we have, but what's exciting is we'll get to listen to all of it in a couple of weeks. Maybe that's enough spitballing for now. I'll talk a little bit more about the case in 20 minutes or so, but should we turn to some of the changes that have already been made this year in response to the pandemic?
Sure, thanks. It's really an exciting time for health and welfare plans, I guess. And now we can move on to some other exciting things. I'm going to start by talking about the cafeteria plan rules and some of the guidance that has been issued in connection with cafeteria plans by the COVID-19 guidance that's been issued and other changes in law. Cafeteria plans, just to give a little background, are plans that allow employers to offer their employees the choice between cash or a certain group of non-taxable benefits. The most common non-taxable benefits that are offered by a cafeteria plan include the election of health coverage itself, payment of premiums for health coverage on a pre-tax basis, and flexible spending accounts, both health flexible spending accounts or dependent care flexible spending accounts, or FSAs as they're often called. The benefit of having a cafeteria plan is that elections between cash or non-taxable benefits outside of a cafeteria plan result in an employee being taxed on the value of the cash, even if the person elects the non-taxable benefit. So a cafeteria plan is an exception from that general tax rule. And in order to get that benefit, there are a lot of restrictions on how those elections need to be made and how much can be put into a cafeteria plan and how the reimbursements need to be made. In connection with the COVID pandemic, there's been Congress has enacted certain laws, there's been executive orders, and various agencies have also issued specific pieces of guidance that are under their auspices. In the context of cafeteria plans, the IRS issued 2 notices, 2020-29 and 2020-33, which are aimed at providing employees and employers with greater flexibility with respect to healthcare elections, the period during which claims can be submitted, and the limits that apply under cafeteria plans. In addition, the Coronavirus Aid, Relief, and Economic Security Act, CARES, which is the more common way to refer to it, made changes with respect to the type of expenses that can be reimbursed under a health FSA under a cafeteria plan. I think it's helpful to kind of understand before we get into the actual changes made by the guidance, what the general rules are pre-guidance, because number one, we're going to go back to those in most cases. And number two, it helps to understand the value of the guidance that we've received when we understand what it would look like if we didn't have the guidance. The first topic is changes to elections and how elections are supposed to be made under a cafeteria plan. One of the restrictions that applies is that an election to either get health coverage, pay your premiums, or contribute amounts to a health FSA or dependent care FSA must generally be made prior to the plan year to which they relate, and they cannot be changed except in very limited circumstances, the most common one being a change in status. The changes under the cafeteria plan rules are set forth in IRS regulations, and they are very specific. They require that an election has to be not only on account of a change in status, which, believe it or not, has rules about what it means to be on account of a change in status, but also consistent with the change in status. And there are rules about whether a specific change is consistent with a specific change in status. For example, the rules provide that if you have a baby, it's consistent to add that baby to your health coverage. It is not consistent to drop all of your health coverage. Under the guidance that we got with COVID, under Notice 2020-29, there is a broadening of the cafeteria plan election change rules that can be very valuable to participants in the plan. And it also allows employers to give some flexibility to its employees. The guidance specifically provides that employers can amend their plans to provide that all employees who are eligible to make contributions, even if they're not currently making contributions, can make prospective changes to their elections regarding employer-sponsored health coverage and dependent care and healthcare FSAs for calendar year 2020. So we're well into 2020, and under the usual rules, we would not be able to change those elections, but for a change in status. With respect to health coverage, employees can be given the ability to make a new coverage election if they initially declined coverage, revoke an existing election and make a new election, so change your option, for example, from a PPO to an HMO or a higher level of PPO, et cetera, and revoke an existing coverage election. If the employee is going to revoke an existing coverage election, however, they have to attest to having comprehensive health coverage or agree to immediately obtain such coverage. And the IRS issued a model attestation that the employer can rely on and the employee can use to provide that information to the employer. With respect to health FSAs and dependent care FSAs, the employees can be given the right to prospectively revoke an existing election, make a new election, or increase or decrease the amount that they've contributed to the FSA over the course of the year or will provide going forward. The election changes permitted under the guidance are available to all eligible employees, whether or not they're affected by the COVID-19 pandemic. You might have heard in other sessions that we've had under the university that in certain cases, the guidance requires you to have an adverse effect from COVID-19 in order to take advantage of the changes. That's not the case in cafeteria plans. There is no requirement that you're affected or not affected. You can also make the changes to the elections regardless of whether they meet the normal election rules. In other words, they don't have to be on account of a change in status, and they don't even have to be consistent with the change in status. An employer, however, is not required to modify its plans to provide for any or all of the changes, so they can pick and choose. And we'll talk a little bit more about the considerations in that regard later. If an employer does decide to permit some or all of the changes, it needs to amend its plans to set forth what it's doing. The plan amendment is also got special guidance because normally you have to amend your plan before you offer the benefits. But in this case, the changes can be made by an amendment that's adopted no later than December 31st, 2021, and it can be retroactive to January 1st, 2020. If it's retroactive, the employer has to give a notice to its employees of what the changes are, and the plan has to be administered in accordance with that notice. Another area that we've received guidance in relates to the provisions of cafeteria plans that are designed to prevent the deferral of compensation. A cafeteria plan cannot provide benefits that defer compensation. It's a general principle of a cafeteria plan. So for example, if a plan permits an employee to carry over amounts that they've elected for 1 year to pay benefits in another year, that's a deferral of the compensation, and the cafeteria plan would violate the cafeteria plan rules. This is frequently called the use it or lose it rule. It's kind of a hallmark of cafeteria plans. I'm sure that most people on this call will understand what that means. The rule generally requires that amounts that are allocated to cafeteria plans have to be used for claims incurred in the year to which the election relates. They can't be used to reimburse claims for later years or to provide benefits for later years. The participant, in other words, has to either use the amounts or lose the amounts in the cafeteria plan. A plan doesn't violate the use it or lose it rule by providing what's called a run out period, which is essentially an administrative rule that is available so that claims that are incurred late in the year can be processed early in the next year, but they relate back to the prior year. Normally it addresses claims incurred later in the year, but it could address any claims that are incurred at all in the year to which the run out period relates. This is usually a brief period following the end of the year, and it's included in almost all cafeteria plans. Beginning in 2005, the IRS issued guidance that permits employers to include a grace period in their plans as an exception from the use it or lose it rule. A grace period is a period that can't be more than 2.5 months following the end of a plan year. And what it allows is that any claims incurred in that 2.5 month period, or shorter period if the plan so provides, can be reimbursed by amounts that were contributed for the prior plan year. So it sort of extends the period of coverage of the cafeteria plan for a brief period of time after the plan year. The amounts that are allocated to the plan for the plan year to which the grace period relates are charged against any limits that apply to the cafeteria plan for the year to which it relates, and any amounts that are remaining after the end of the grace period and any run-out period that you have relating to the grace period have to be forfeited. So it's essentially just an extension of the plan year, so to speak. In 2013, the IRS issued a change in law that limits the amount of contributions that can be made to a health FSA under a cafeteria plan. And in connection with that, the IRS further whittled away at the use of the use it or lose it rule, okay, I've got that, by permitting employers to add a carryover provision to their plans. In connection with the maximum contributions, the carryover allows up to $500 to be taken from one plan year and added to the limitations of the next year. And so it can up to $500, or if the plan provides for less, can be used to pay claims in the next plan year. So it's definitely an extension of the exception to the use it or lose it rule. The carryover cannot count, it doesn't count against the limits. So for example, in 2020, the limits for the FSA are $2,750. And if the plan provided for a carryover of $500, it wouldn't count towards the $2,750. So it's an additional amount. Also, you can't carry over more than you have left to be reimbursed under the plan. So if you didn't have $500 left after submitting all claims for the prior year, you could only carry over whatever you had left. A plan cannot include both a grace period and a carryover provision for the same plan year. And carryover provisions for dependent care FSAs are not permitted. So those are kind of the basic rules about when you can submit claims and how much you can submit. And we did get guidance in connection with the COVID pandemic under Notice 2020-29, which modifies some of the rules relating to the grace period and the carryovers. The guidance provides that an FSA account with a grace period ending in 2020 or the 2020 plan year may permit employees with unused amounts at the end of the grace period or the plan year to use those amounts to satisfy claims incurred anytime during 2020. So it extends the grace period essentially for several months after the original March 15th in a calendar year plan. Consistent with the rules in effect prior to COVID, you can't use amounts under one type of FSA to provide benefits under another. So for example, you can't use amounts that are allocated to a health FSA to pay dependent care claims or vice versa. And you still can't have a grace period and a carryover provision for the same plan year. The guidance also provides, this is back to Notice 2020-33, that they're going to modify the amount of the carryover from $500 to an indexed amount. And unlike the other COVID guidance that I've discussed, this is going to be an ongoing change. So the carryover amount is going to be indexed each year going forward, and it's supposed to be 20% of whatever the maximum FSA amount is for the applicable year. So for 2021, it's going to move up to $550, and this year it's $500. Again, like with the other guidance, a plan amendment is required to reflect the changes to any carryover or grace period provisions. That amendment has to be adopted by the end of 2021, can be retroactive. If you are going to do retroactive, you have to give a notice and administer in accordance with the guidance. In the case of the carryover, going forward, if you don't have it in your plan, you're going to have to amend the plan prospectively, because we'll go back to the normal amendment rules after the special COVID guidance expires. The last topic to be discussed under cafeteria plans is what can be reimbursed under health FSAs. In general, health FSAs can only reimburse expenses for items constituting medical care. And there's a special definition of that for cafeteria plans. It's not just anything that you would maybe normally think of as medical care. And the IRS has limited this over time. In particular, the Affordable Care Act, our birthday child, provided that beginning as of January 1st, 2011, a health FSA was not permitted to reimburse amounts for over-the-counter medications unless the employee had, or the individual had, a prescription other than insulin, which was a special case. The CARES Act, however, provides that over-the-counter medications purchased after 2019 are reimbursable from a health FSA. And the types of medications that are covered by the CARES Act include non-prescription pain relievers, cold and allergy medications, antacids, and the like. It doesn't include things that are beneficial for general health, such as vitamins. It also indicates that expenses for menstrual care products are treated as expenses for medical care and so can be reimbursed. And in order to get reimbursement for the expanded items, the health FSA has to be amended to provide for this. Unlike the extended guidance that we got for other items under the COVID guidance, The CARES Act does not provide for an expanded amendment period for this, so it's probably prudent to amend your plan before you start making reimbursements for these items. As I mentioned earlier, the employers don't have to put all of these changes into their plan, or any of these changes, but presumably employers do want to help out their employees and allow them to make some changes. We have a slide here that gives some considerations that employers might want to consider to make sure that they're not encouraging adverse selection, or that they don't get left holding the bag for a lot of liability. As you may know, in the case of a health care FSA, you have to offer the full amount of the elected contributions for the entire period of coverage. And so you could have a situation where someone has already received reimbursement for their full amount, and then they want to revoke their election, and that can be left with the employer having to fund those benefits. So there, you might want to put them all in, you might want to put some in, but there's some things to consider. I'm now going to turn it over to Stephanie, who's going to talk about some things that we've gotten as far as guidance in connection with high deductible health plans, telehealth, and some more on the ACA.
Thanks, Debbie. I mean, I think it's really notable that this pandemic is affecting health plans in a way that, a natural disaster or a recession does not, because individuals are affected differently. You see people who are needing to use much more by way of, healthcare expenses or dependent care expenses than they initially expected. Perhaps because, they've contracted COVID, or their child isn't in school and needs care. And then you see other people who aren't able to access their flexible spending account or to use their dependent care account because the care simply isn't available for them. So I think the guidance we're seeing is much more expansive and much more flexible than what we've seen, say, with Hurricane Katrina or with the 2008-2009 recession. And it's much longer lasting because it's not a one-time event that is over relatively more quickly. So I take it, Debbie, that's what you're seeing as well. This is very any other health type event we've seen.
Absolutely. And that's why there's different considerations for employers to also take into account, because it isn't a one-shot deal and it's not going to apparently go away anytime soon. I also don't know if we're going to get an extension of these types of relief for 2021, but the closer we get to the end of the year before things start opening up, it may be that we get some additional relief going forward as well.
Yeah, and it seems like the agencies have been really, fairly on the ball with issuing new guidance and, new FAQs. So I'll go through some of the guidance that we got even way back from just when this was starting in the U.S. at the, so-called beginning of COVID, at least for most U.S. employers and health plans, and then through some of the more recent guidance. And to start with on this first slide, this just runs through a few of the changes in the initial IRS notices and then the Families First Coronavirus Response Act that health plans must cover without deductible and without cost sharing. And this includes high deductible health plans. First, they must cover diagnostic COVID testing, and I'll talk a little bit more about the details. They must also cover services that are required to determine whether a COVID test is necessary. And also something that's not relevant immediately, but will hopefully become relevant in the next, months to years, are COVID-19 vaccines. Now, I think the one we see the most questions about is perhaps the first one, the COVID testing. Not all COVID tests are required to be covered by your health plan. The COVID test must be diagnostic. So either you have signs or symptoms of COVID or you've been exposed to someone with COVID. The FAQs that have been issued by the agencies have made very clear that this is not intended to cover surveillance testing that your employer requires for you to go back in the office, testing because you are wishing to see a relative and you want to be sure that you don't have COVID in advance. Anything that's not for a diagnostic, medically necessary reason is not required to be covered. There's also the provision that it must be determined medically appropriate by the individual's attending healthcare provider. And initially, there were a lot of questions about what that meant too. That's much more flexible, it turns out. The way the agencies are looking at this is it's the person who is responsible for providing healthcare to the individual and acting within the scope of their license. So this doesn't mean that the individual has to get a referral from their primary care physician in order to get a COVID test. It can cover, for example, going to a walk-up clinic or to a drive-through clinic, as long as there is someone there acting within the scope of their license who determines that a diagnostic COVID test is medically appropriate. And that's not to say there isn't COVID testing available at a number of sites for free, even when it doesn't fall within this diagnostic COVID testing category. It's just not required to be covered by the health plan. On the second point, services administered in connection with a provider's determination of whether a COVID-19 test is necessary. The most common example you hear about here, and something I think we'll see more often going into the winter, is a flu test. You know, if you have somebody coming into the doctor's office, they're showing some signs or symptoms of illness, and it's hard for the provider to tell whether they might have COVID. The doctor may perform another examination or another test to rule out other illnesses like the flu. Those services are required to be covered without deductible or cost sharing. I think that provision is going to become a little less relevant now that testing is much more widely available. Remember, this was put into place back in March when it was very difficult to get a COVID test. So people were getting a lot of other tests to rule out COVID if they could, or to rule in, oh, this is just the standard flu. That said, it is still relevant and required to be covered. And then last, of course, the COVID-19 vaccines. Hopefully something we'll be seeing more on soon. And then I don't think we need to go into detail about this today, but there are extensive provisions related to what reimbursement rates are used. This is something that health plans and insurers either negotiate with the provider before the public health emergency. Otherwise, cash prices can be posted on the website or lower rates negotiated. And providers can be penalized if they fail to post their prices. Another then important subject to talk about is high deductible health plans that can make changes but are not required to do so. As I'm sure most of you listening are familiar, a high deductible health plan is a health plan that typically requires participants to cover all healthcare costs incurred until they reach a deductible. And there are very limited exceptions to that. For example, a plan provides preventive services before the deductible is reached. As part of the COVID-19 pandemic, new rules allow a high deductible health plan to cover, either without a deductible or cost sharing, or with a limited deductible or cost sharing, two new categories of medical expenses. The first is medical expenses for COVID-19 treatment. And the second is for plan years that begin on or before December 31st, 2021, medical expenses for telehealth and other remote care services. You can see that both of these categories are really critical during this pandemic. The first is to help ensure that people are getting COVID-19 treatment without concern for a high deductible that they may have. And the second is to encourage people to continue to access care without placing a high burden on the in-person healthcare system. That said, this isn't something that I'm seeing a lot of employers adopting. Both of these could be very expensive. COVID-19 treatment, obviously, for some, there are little to no costs, but for others, there can be, days, weeks, months of significant hospital, ICU types of treatments. So it could be very costly to amend your plan to provide that treatment is provided without a deductible or any cost sharing. On the telehealth or remote care services front, providing those services without a deductible at this stage means that you may be providing nearly all services without a deductible or cost sharing. I mean, until March, I think most of us had not considered going to many of our regular doctor's appointments remotely or via telehealth. But now nearly all standard healthcare providers are offering those types of services. So it's something that could be more costly for health plans to adopt. I've listed on this slide the IRS guidance that talks about the ability for high deductible health plans to offer these, if anybody wants more information. But talking about telehealth a little more, as I mentioned, we're seeing more and more individuals, employers, and the government wanting to make sure that individuals have access to safe healthcare. And the slides that come next talk a little bit about one of these initiatives. Over the years, we've seen many employers who want to offer some sort of medical benefits to their employees who are not benefits eligible. Maybe it's individuals who are working, fewer than 20 hours per week, and the employer would like to offer them, say, a beefed up employee assistance program or a telehealth program that provides for 10 visits with a nurse practitioner or a doctor remotely. This is something that sounds like a great benefit, and there are a lot of great companies that provide those benefits, but can cause significant issues under the Affordable Care Act. This is because any employer program that provides medical care will generally be considered a group health plan that's subject to federal requirements and market reforms, which includes the Affordable Care Act requirements that require that all preventive care be covered free of cost, and that require that the plan not contain any annual or lifetime limit mandates. This is a major problem for those types of plans, the standalone telehealth plans and employee assistance plans that provide significant medical benefits. Something that employer organizations started asking for, in particular during the COVID pandemic, was increased access to telehealth benefits for non-benefits eligible employees. And at the end of June, the Department of Labor, the Department of Health and Human Services, and the Department of Treasury responded with some joint FAQs that provide some latitude for employers who want to offer those benefits to their non-benefits eligible employees. In short, the FAQs provide that for any plan year that begins before the end of the COVID-19 emergency, any plan that solely provides for telehealth or remote care services is exempt from group market reforms, meaning that that telehealth plan that otherwise would have violated the Affordable Care Act's requirements will no longer be in violation of those requirements. Now, there are a few other things that must be considered here. First, the relief is limited to arrangements that are sponsored by a large employer, and a large employer is one that is a large employer under the Affordable Care Act. The second is the arrangement must be offered to employees or dependents that are not eligible under any other group health plan. And the agencies clarified that a number of other provisions continue to apply to these telehealth arrangements. These provisions include prohibitions against pre-existing condition limitations, rescissions, discriminations regarding health status, mental health and substance use disorder parity. But more importantly, what the agencies did not clarify, but what we expect continue to apply, are also requirements like COBRA obligations, the Form 5500 filing requirement, and plan document and summary plan description obligations. We've seen employers continue to ask the agencies for more guidance about how a limited telehealth benefit provided to non-benefits eligible employees can comply with all of these other requirements that might apply to such a plan, and are hopeful that the agencies will provide some guidance here. Otherwise, employers that want to offer these benefits should make sure they're considering not only what kind of benefit are we going to offer and to whom will we offer it, but also how are we going to comply with these other pieces of the puzzle, Is there a way to put it into our RAT plan, but clarify the population that it's for, so that maybe that covers some of the other pieces like COBRA, the Form 5500 in the plan document? Is our COBRA provider willing to cover this? Is the telehealth provider willing to cover this? Just continuing to think about those pieces until we have more guidance about how this will apply. Next, as promised, an update on the Affordable Care Act. I mean, and I suppose one update is that if the Affordable Care Act is held unconstitutional, we don't have to worry about the Affordable Care Act mandate, and people can offer telehealth benefits to whomever they want. But, you know, Debbie and I covered a lot of this earlier, but to give some background, the Affordable Care Act included what is often referred to as an individual mandate. The individual mandate requires that individuals either have health insurance or pay what is euphemistically referred to as a shared responsibility payment, what you and I might think of as a penalty, and what the Supreme Court found in 2012 constituted a tax. That was part of the case NFIB versus Sebelius, where the Supreme Court upheld the constitutionality of the individual mandate as a valid exercise of Congress's taxing power. As Debbie mentioned, under the Tax Cuts and Jobs Act of 2017, the Affordable Care Act was revised so that the shared responsibility payment for individuals was set at $0, effective as of January 1, 2019. Almost immediately, a group of 20 states, led by the state of Texas, challenged the constitutionality of the Affordable Care Act, and in particular, the individual mandate. This is because the individual mandate was previously upheld as a valid exercise of Congress's taxing power, and the tax no longer existed. The district court in Texas agreed with the state of Texas that the individual mandate was unconstitutional. And in fact, the entire Affordable Care Act should be invalidated. The case went up to the Fifth Circuit. The Fifth Circuit agreed that the requirement to maintain health insurance without an associated tax was unconstitutional, but it remanded the case to the district court for further analysis on whether the individual mandate could be severed from the rest of the Affordable Care Act. Something that's particularly interesting here is that the federal government throughout the case generally has not defended the constitutionality of the Affordable Care Act. At times, it is argued that only the individual mandate should be found unconstitutional. At other times, it has supported the district court's decision in its entirety. So, as Debbie noted, 17 states, led by California, asked to intervene successfully in the case so that they could represent and defend the constitutionality of the Affordable Care Act. And in March 2020, the Supreme Court agreed to hear the case. The case is now set for oral argument on November 10th, 2020. And I think we've actually talked through a fair amount of the possible results and ramifications. So now what we have to do is wait and see what happens. One thing to consider, assuming the Affordable Care Act does remain in play, is a general counsel memorandum that came out in February talking about the statute of limitations on employer shared responsibility payments that the IRS applies. Normally, the IRS has a 3-year statute of limitations from the later of the date a return is filed or due. And when you're thinking about employer shared responsibility payments, that is the payment that an employer must make if they fail to offer coverage to full-time employees, or if they offer coverage but it's not minimum value or not affordable. Normally that information is reported by the employer to the IRS on a Form 1094-C or 1095-C. And I think many of us had interpreted the statute of limitations to begin running on the employer shared responsibility payments as 3 years from the date the 1094-C and 1095-C were due or filed. Notwithstanding the IRS's guidance, in February, the IRS released a chief counsel memorandum concluding that those forms do not actually start the running of the statute of limitations. And you might be asking why. The reason why is that case law has held that for a return to start the statute of limitations running, the return must provide sufficient information in order for the tax liability of the employer or the person filing the return to be calculated. And in this case, as any employer who's responsible for filing these forms will know, you can't actually calculate an employer's shared responsibility payment from the forms 1094C and 1095C. You will know whether an employer might be liable for a payment by looking at those forms, because you'll see whether they failed to make an offer of coverage or the offer of coverage wasn't affordable or didn't provide minimum value. However, what you can't tell from those forms is whether an employee went to an exchange and got coverage or received a premium tax credit. Of course, you and I know that there's absolutely no way for an employer to have that information. However, the IRS has used that fact to say that there's no way the statute of limitations can start running. You don't know that information. You haven't provided that information. So in essence, as far as we can tell, the IRS's position is that there's no statute of limitations because there's no return sufficient to start the statute of limitations running. No return files all of the data needed to calculate the tax liability. I think there's a lot of objections to this idea, but you'll see even now that the IRS is very behind in assessing employer shared responsibility payments. I've seen them from 2016 and 2017, and I've heard they're on 2018 now. I don't think I've seen a 2018 one myself, Debbie and Karen. I don't know if you have either. But it's not comforting to know that they can continue to come.
What employers are even subject to COBRA to begin with. Also be aware that COBRA, the provision, the obligation to provide COBRA, the penalties that can flow from noncompliance, that those are joint and several liabilities of all of the controlled group members. Be aware that qualified beneficiaries can be employees, former employees, retirees in some instances, as well as spouses and dependent children. And be aware that there are a number of COBRA qualifying events. I think most of you are aware of those. Termination of employment for reasons other than gross misconduct, reduction in hours, Medicare entitlement, the employer's bankruptcy with respect to special rules about retiree coverage that ends on account of a Chapter 11 bankruptcy proceeding of the employer, divorce, legal separation, loss of dependent child status, and in some instances, extension of an initial COBRA period by reason of a Social Security determination. And so the COBRA periods associated with these events are either 18 months, 29 months, or 36. Again, with the possibility that you can be in the midst of an initial COBRA period and then have a secondary qualifying event that enters the picture with an extension of that initial COBRA coverage period. So we really want to focus on COBRA notices during this portion of our presentation, but be aware that there are 4 different types of COBRA notices. There's the initial or general notice, there's the COBRA election notice, the notice of COBRA unavailability, and the notice of COBRA termination. We're really going to focus on the first 2 of these types of COBRA notices. So let's get going with this. The initial general notice. That is the notice that the plan administrator must provide to the employee and spouse upon the employee's first becoming covered under the employer's group health plan. So what does it mean to provide it when the employee first becomes covered? It's a 90-day window. The general rule is it's a 90-day window subject to a few nuances that we provide here. In particular, for example, if there were an actual COBRA qualifying event within that first 90-day period, the initial COBRA notice would have to be delivered earlier than that, the end of that 90-day period. You wouldn't get the full 90-day period, in other words, and you'd actually then start the clock running for the COBRA election notice, which we will get to in a few moments. It's a single notice that can be delivered to the place of residence of the employee and spouse. But again, there are some nuances to that depending on information that the employer reasonably has about the places of residence of the employee and spouse, whether they live together or they are known to have separate residences. What's the content of this initial general notice? We won't go through all of the points here, but they're listed in the slides. Generally, you obviously have to identify the name of the plan. You have to provide names and contact information of individuals who can provide additional information about the plan and the COBRA coverage. And you have to explain generally what COBRA coverage is about. Who can be a qualified beneficiary? What is the range of the qualifying events? What are the timeframes associated with those qualifying events? You have to explain that the qualified beneficiaries have some obligations. This isn't something that the qualified beneficiaries can just sit back and have done for them. They have some notice obligations as well, as we will see as we go through our remaining slides. And ultimately, you have to include a statement that the notice is not necessarily all-inclusive and that further information can be gleaned from a summary plan description, the SPD, or obtained by contacting the plan administrator. So after you get the general notice out to participants, what happens if there is a COBRA qualifying event? Well, the employer, first of all, has an obligation. Within 30 days of an employee's termination of employment for other than gross misconduct, reduction in hours, or Medicare entitlement, or the start of bankruptcy proceedings in the case of the retiree coverage that I mentioned a few moments ago, the employer has the obligation to get that notice of these kinds of qualifying events to the plan administrator. By contrast, the qualified beneficiaries themselves have a notice obligation. Within 60 days, they have a longer window, they have to provide notice to the plan administrator of a divorce or legal separation of the spouse from the employee, or the loss of dependent child status, or a case of a secondary COBRA qualifying event that may occur in the midst of an existing ongoing initial COBRA period. Additionally, if a qualified beneficiary receives a Social Security Administration ruling of disabled status within the first 60 days of an initial COBRA period, then that qualified beneficiary has 60 days in which to communicate that to the plan administrator that can entitle that qualified beneficiary to a longer COBRA period. That's the 29 months, in other words, 11 months beyond the initial 18 months. Similarly, if SSA makes a determination that the disabled person is no longer disabled, there is a 30-day window that the qualified beneficiary has to communicate that change to the plan administrator. So now you've communicated the qualifying event. So what happens next? Now we turn to the election notice itself. This is a notice that the plan administrator has to provide within 14 days of receiving notice about the existence of a COBRA qualifying event. This election notice is even more complex. There's a lot of information that has to go into it, and it has to be written in a manner calculated to be understood by the average plan participant. This can be a very tall order because there's a lot that has to go into it, as I said. I'm reminded of years ago, back in the time of ARA, when the former head of the Employee Benefit Security Administration provided a COBRA video explaining to the public how the premium subsidies work. And I distinctly remember her impassioned plea that people really pay attention to it, because she said, people, this stuff is really complicated. So again, we won't go through all of the content, but it's here on the slides. But again, you have to provide the identity of the plan, and you have to provide the name and the contact information of the party responsible for the administration of continuation coverage. I underscore that because we will come back to that later when we talk about trends in COBRA, in litigation, COBRA-related litigation. You, of course, have to identify the qualifying event that is the trigger for the COBRA notice. You have to identify who is a qualified beneficiary and explain that the qualified beneficiaries have separate and independent rights with respect to electing COBRA coverage. You have to indicate the method of electing COBRA, the time frame for doing it, what that involves. You have to describe what the qualified beneficiaries have to do in the way of payment, what it costs, the timing of those payments, both the initial payment as well as subsequent payments, and where those payments have to be sent. You have to explain that there are events that could serve to extend further the initial maximum COBRA periods, which of course those maximum COBRA periods have to be described in the notice as well. And in the end, you have to provide that similar statement about the fact that the notice is not necessarily all-inclusive and that further information can be obtained from the plan administrator or the summary plan description. But overall, you have to explain what the coverage involves, all the details about electing it and paying for it, as well as explaining the ramifications of waiving the coverage. What happens if you miss the deadlines? In terms of electing and paying for COBRA, this is now yet another set of timelines that COBRA administrators and qualified beneficiaries have to be aware of. For example, the qualified beneficiary has a period of at least 60 days to elect to get the COBRA coverage. And that 60 days starts to run from the later of the loss of coverage due to the qualifying event, or when the COBRA notice is actually provided. And that's generally a postmark date concept in terms of the provision of the notice. After electing COBRA, there is a 45-day period in which the qualified beneficiary has to make the initial payment retroactive to the beginning of the coverage period. Thereafter, payment is made on a monthly basis, so the timing of that is typically it's the first day of the month. And then there is a 30-day grace period for each of those periods. And so when we look at this time frame, we can see that with a 60-day election period, and this is before we even get into the COVID-19 extensions of some of these dates, there's a 60-day election period and a 45-day payment period. And your notices should emphasize that you don't actually have the coverage until and unless you both elect it and you pay for it. So it's not as if coverage is continuing and a qualified beneficiary can then decide not to take the coverage or pay for it. But it does give, and this has been a criticism of COBRA in the past, it does give the qualified beneficiary a fairly long sort of free look. Do I need it? I can bide my time. Do I get another job? Do I get other coverage before I really have to make a decision to elect and then ultimately pay for it? So let's focus for a moment on the penalties for failure to comply with COBRA. They can really mount up if you have multiple penalties. And the penalties are both in the form of excise taxes under the federal tax code. Those are $100 per day for each affected qualified beneficiary, with a $200 maximum per family per day, and an overall statutory maximum of $500,000. And that's where the penalties are not willful or intentional. On the ERISA side, it's a $110 a day ERISA penalty per failure. So you can see how a combination of these penalties can really add up if you have multiple, particularly if you have multiple failures. And again, we underscore that the penalties and the obligation to provide the coverage is a controlled group-wide obligation. So be aware that an employer that may not even understand that it's part of a controlled group can be tagged with some of these obligations unwittingly. So, we've gotten through all of that. Now we're ready to talk about our first major development here, and that is the COVID-19 extended COBRA deadlines. In May of this year, the Departments of Treasury and Labor issued some special rules that provide a variety of extended deadlines that are employee benefit plan related, including COBRA, certain COBRA related deadlines. And what these rules do is establish a so-called COVID outbreak period during which a number of these deadlines are held really in suspension. It's tantamount to a suspension because for purposes of determining when these deadlines come due, you disregard entirely the outbreak period. What is the outbreak period? It started March 1 of this year, and it ends 60 days after the announced end of the public health emergency. And that anticipated announced end has changed multiple times since March 1 and since these rules were established. For example, we were in a period of time when the extended anticipated lifting of the national public health emergency was scheduled for October 23, which put into December the end of the outbreak period and then a continuing of the running of various COBRA-related deadlines. But earlier this month, there was a further extension, and that extension is January 20, 2021. So you can see 60 days after that puts us after March 1 of 2021. So we are now a full year plus over the initial start of the outbreak period. This is really unprecedented to have a suspension period for such a long period of time. And by the way, there are other deadlines that have been extended as part of this guidance that we won't go into. For example, deadlines relating to ERISA claims and appeals. People have a longer period of time, quite an extended cushion now, for actually filing claims and going through the claims and appeals process. So what are the purposes for which the outbreak period is disregarded? Well, it affects employers and plan administrators insofar as the deadline for actually getting the COBRA notices out is extended through these rules. For the qualified beneficiaries, their deadline to notify the plan administrator of their qualifying events, those qualifying events that are within their responsibility to communicate, are affected by these extended deadline rules. Their election period, the 60 days, and then all of the payment timing, the 45 days, the monthly payments, and the 30-day grace periods are all held in suspense by these new extended deadlines. So you can see how an already complicated series of deadlines has been made even more complex. Anecdotally, however, and practically speaking, we don't know the extent to which people are actually taking advantage of these extended deadlines. We would advise employers and plan administrators don't use these as a reason to dilly-dally on getting the notices out. That's a powder keg waiting to explode if you intentionally use the deadlines to delay on getting COBRA notices out, because we know communicating with participants and other qualified beneficiaries is critical. And by the way, we also would advise that there be supplemental notices to people who have already received COBRA notices to let them know about these extended deadlines. And then again, if those extended deadlines become further extended. We also don't know if qualified beneficiaries are taking a much longer wait and see approach to delaying on actually deciding whether they're going to elect COBRA or pay for it. We would think that a qualified beneficiary that is very nervous about having continuous health coverage, perhaps they become ill with COVID or other illness, that they will want to get that notice and they will want to elect COBRA and pay for it to know that they have no gaps in coverage. But potentially we are now in a one-year period of suspense on these various deadlines. Be aware that periods that elapsed before the beginning of the outbreak period will count, and we won't go over both of these examples, but in the first example, you can see we've assumed that an individual, a qualified beneficiary, was in the midst of a 60-day COBRA election period at the beginning of the outbreak period, with 25 days having elapsed, that individual would have 35 days after the end of the outbreak period to elect to take COBRA. So the next thing we'd ask, well, let's go back to ARA that I mentioned earlier. Why don't we have premium subsidies? Are there subsidies that possibly may come into play? There are at least 4 bills presently introduced in Congress that all would provide some premium subsidies and, like ARA, would provide for employers to recoup those subsidies through a series of payroll tax credits. 3 of these bills would provide a 100% subsidy, so they part ways from the lesser subsidy that was provided under ARA. And one of the bills, as the premium subsidy, would use the active employee rate for health insurance coverage. Now, we might ask, what's happening to these bills? We're deeply into the COVID pandemic period. Stephanie, what are your thoughts about this? Are we going to, you think, see some movement on these, or are these pretty much dead in Congress?
I don't know that they're dead in Congress. I think, every morning still you see news about, even, this morning you see that Democrats in the White House are perhaps making progress on a stimulus package, but that the Republicans aren't sure, or that Republicans in the White House are working on something, but the Democrats aren't sure. I'm not sure that we'll successfully see a stimulus package go through before an election, given the uncertainty that's happening over the next couple of weeks. You certainly see people still working actively towards something. So I wouldn't be shocked, but I would be surprised.
Thank you. And my impression, too, is that this has been stymied by what I'll call the dynamics in Congress. But we know that a number of congressional seats are up for grabs. So this is something for all of us to really pay attention to, because we might see some movement on this depending on the election results. Well, now we've seen, and we've always known that COBRA was complex, but let's talk for a moment about trends in COBRA litigation. I'm an old timer. I've been around since the beginning of COBRA, and my recollection is that those earliest COBRA cases were more in the nature of individual plaintiffs seeking to have a solution to a dispute over, did they get a COBRA notice, did they elect it timely, or were they denied COBRA because their employer said their termination was due to gross misconduct. And while those cases are not exactly invisible even now, there is a new wave of litigation that has captured our attention, and it's becoming alarmingly intense, particularly in this COVID area with a lot of layoffs and furloughs, reductions in hours. So more and more people who need and elect COBRA coverage. So these are class action cases, large groups of plaintiffs, and the focus is all on the COBRA election notice. Now, I'd like to start out by giving a shout out to 2 of our colleagues, 2 very skilled ERISA trial lawyers, Nancy Ross and Richard Nowak, who in May published an excellent article in Bloomberg News. We have the citation at the bottom of this slide, and I would urge our listeners to look at that article. It's a concise, excellent summary of some of the high-level points I'm going to be making now. So the theory underlying these class actions is that if a number of individuals got the same defective COBRA notice, then there are common harms that they all suffered. And most of these cases have been brought in the state of Florida. That's because there are 2 leading plaintiffs' law firms there that have led the charge, and their targets are large corporate entities that do business in all or most of the 50 states. But other lawyers in other jurisdictions have jumped on this COBRA bandwagon. We'll go over a few of the kinds of claims. Keep in mind all of those points on the earlier slide of the complexity of the content. So some of the allegations are that the COBRA notice was not written in a manner intended to be understood by the average plan participant. Yet others are claiming that the notice is not complete, that there are sections that are missing, whether it's about how to elect or how to pay or where to send your money. There is a series of cases in which the allegations are that the notice doesn't give all the names of the health plan administrators. And then there's even a case that the the allegations are that the notice included alarming, intimidating, misleading, really frightening information that there can be criminal penalties on the qualified beneficiary for completing the election materials erroneously. How technical are some of these alleged violations? The answer is, in some cases, highly technical, such that we have two cases against Walmart in one case and Southwest Airlines in another, in which in the Walmart case, it's the ERISA Industry Committee known as ERIC, and in the Southwest Airlines case, it's the Department of Labor itself, that each have filed amicus briefs in support of the employers in the cases in which the allegation is that the notice didn't provide the names of all of the health plan administrators. The regulations are clear that you have to provide the name and contact information for the COBRA administrator and not everybody else. So hopefully this line of cases will go away. What are some typical defenses? Again, I would turn to the wonderful article that our colleagues have published, but typical defenses would be that the named plaintiff has no standing, wasn't really harmed. The class certification should be denied because actually there isn't commonality among the plaintiffs. Or a defense could be that you've substantively complied. There's such substantial compliance. The allegations are so highly technical that indeed the plaintiffs actually had all of the tools and information they needed to elect and pay for COBRA coverage. And to the extent that any of the allegations relate to deviations from the model notices published by the Department of Labor, that in fact, the regs are clear, and the Department of Labor in FAQs and on its web pages has made clear that use of the model notice isn't mandatory. However, in response to this litigation, if you're not using the model notices, you might want to consider using them, and certainly check your COBRA notices or the notices that are being prepared for you by third-party administrator against those models to make sure your content is good. Are you out of the woods if you use a third-party administrator? Not at all. You're still responsible as an employer and plan administrator who's farmed out that responsibility. And toward that end, we would urge you to look at your contract with your third-party administrator and the materials that they're providing your COBRA people to see what does the contract provide. Are you indemnified if the administrator screws up? Can you terminate the contract if and when you feel the provider is no longer serving your COBRA group properly? There are some settlements. We'll skip over this, but just highlight Target. There was a recent announcement of a $1.6 million settlement. That's a class group of 92,000 people. While we don't know the arrangements in place for the attorney fees, we know typically it's a fairly big chunk of a settlement. Now you take the leftover and divide it among 92,000 people and decide for yourselves, is there really a lot of benefit going to the individuals who are supposedly harmed? The next new development is the fact that in May, the Department of Labor issued 2 updated COBRA notices, both in English and Spanish. And those model notices focus on one issue, and that is the Department of Labor wanted to provide clarity between the interface between Medicare and COBRA. And very quickly, if an employee becomes eligible for Medicare, there's an 8-month enrollment period that is timed based on the loss of employment or the loss of coverage associated with the loss of employment, and that if the individual elects COBRA first instead of Medicare, that the individual could end up experiencing a gap in coverage and be penalized for the cost of a Medicare Part B premium. By contrast, if the Medicare is in place, any part of Medicare is in place before the COBRA election is made, then, and by the way, in that earlier example, Medicare eligibility entitlement is one of the circumstances that can result in early termination of COBRA coverage, but it flips if the Medicare is in place before the COBRA election. Then the fact that you have Medicare does not terminate the COBRA coverage, even if you elect another part of Medicare, for example, Part B, after your COBRA election period. But these notices do not incorporate the COVID extended deadline, so there's still a need to supplement COBRA notices with these extended deadlines. We now have a few slides here on best practices. We won't go through all of them, but suffice it to say you should be responding to COBRA inquiries and claims very promptly. You should be reviewing your COBRA notices, whether you're preparing them or you have an outside administrator preparing them. You should look at your service contracts, and you should also consider using the model notice. You should consider having a non-English and non-Spanish language notice, a set of notices for your individuals who are not Spanish speaking or English speaking, but they primarily speak another foreign language. And also consider looking at your fiduciary liability insurance in the event there is a lawsuit. What does your insurance cover? What does it not cover? Who is covered? And it is sometimes surprising for employers to learn that excise taxes and penalties are typically not covered under these insurance policies, nor are actually benefits if you actually get tagged with liability that you can't insure and you end up having to self-insure some medical benefits. The actual benefits are typically not covered. And at this point, let's save M&A transactions for a rainy day. That is not a new development, but in our transactional practice, we increasingly encounter buyers, either asset purchasers or purchasers of stock of companies, really do not understand the circumstances under which they can be tagged with COBRA liability in a transaction for people that have no relationship whatsoever and will not otherwise have a relationship with the buyer. It's a situation where a seller may have liability that then shifts to the buyer in certain circumstances when the seller ceases to have a group health plan anywhere in its controlled group. And we do have a few minutes left, Stephanie, so I'd like to turn it back over to you for our odds and ends, or as my London daughter would say, some bits and bobs remaining, and see if we have any time for some questions. So thank you, everyone.
Thanks very much, Karen. I like the bits and bobs, so I will turn to that. Karen mentioned this during her presentation, but just a slide to highlight it. COBRA election and payment deadlines weren't the only deadlines that were delayed. Other deadlines that were delayed for the COVID-19 pandemic include the deadlines for filing benefit claims, for appealing adverse benefit determinations, for requesting external reviews, for submitting requests for additional information. So as you're going through kind of the day-to-day operations under your health plan, a lot of these are probably handled by your health insurer or your administrator. But to the extent that you're involved at all in those components of operations, make sure you're accurately reporting the fact that the deadline is not what it used to be, that it has been extended, and that the extended date, could continue to be pushed out. Of course, we have an idea of what it is at the moment, but that's changed several times over the last 7 months and could continue to change from here. Then I'll just briefly talk about this interesting 10th Circuit case, the Primera case. It's particularly important for our 10th Circuit friends in Colorado, Kansas, New Mexico, Oklahoma, Utah, and Wyoming. And the underlying facts of the case aren't particularly important, other than that you should know the plan participant's claim was denied as medically unnecessary. Their appeal ultimately worked its way through the plan and up to the courts. The district court determined that the appropriate standard to review Primera's decision on the claim was whether it was arbitrary and capricious. And they also determined that Primera had not acted arbitrarily or capriciously in determining that the claim was medically unnecessary. The reason for that is more than 30 years ago, the Supreme Court held in Firestone that benefit denials should be reviewed using a de novo standard of review unless the plan gives its administrator or fiduciary discretionary authority to determine eligibility for benefits or to construe the terms of the plan. And so when lower courts have applied the Firestone standard, they will apply typically the arbitrary and capricious standard or the abuse of discretion standard if the plan at issue gives the plan administrator or fiduciary discretionary authority. This means the plan administrator should be given a lot of flexibility and deference with respect to their decisions. That wasn't what happened in the Primera case. In the Primera case, the plan document did convey discretionary authority on the plan administrator, and the summary plan description in the case stated that participants could request all pertinent plan documents. However, the court found that there were a few issues. First, it was concerned that the summary plan description didn't describe the discretionary authority conveyed on the plan administrator. Second, participants were provided a copy of the summary plan description, but were not provided a copy of the plan document, presumably unless they requested one. And third, the language in the summary plan description did not suggest that there was another document that affected judicial review. While it said that the participants could request all pertinent plan documents, it didn't say, hey, just so you know, this other document might affect the standard of judicial review. And ultimately, a divided 10th Circuit held that the plan administrator was not entitled to any deference with respect to its decision because the participant didn't have any notice of the plan administrator's discretionary authority. This runs completely counter to Firestone, as the dissent noted. They said it was not supported by ERISA, it was not supported by case law, and it was something of the 10th Circuit's own making, because the plan document here clearly gave the plan administrator discretionary authority. That said, because this is currently law in the 10th Circuit, it's particularly prudent to take a look at your summary plan description, see whether it includes language that the plan administrator or fiduciary has discretionary authority to determine benefits eligibility, or provide plan documents to your participants that include that language. Hopefully this is something that we see resolved, perhaps at the Supreme Court level, but at this point, it's prudent to take a look at those documents. And then we only have a minute left, but we wanted to end just on a light note. One of the questions that I think several of us have gotten is, how does HIPAA apply to COVID status? And one of the first things that I always notice when someone brings up HIPAA is whether they use 2 Ps or 2 As. So always remember it's 2 As, 1 P. But what you can remember in your role as an employer is that information you get regarding an employee's COVID status typically isn't protected health information subject to HIPAA. That's because you're not getting it, usually, through a covered entity or a business associate. A covered entity is a healthcare provider, a health plan, or healthcare clearinghouse, and a business associate is an entity that's providing work or services on behalf of those entities. That's not to say that COVID-19 information isn't sensitive health information, and it may be protected under other laws like the ADA. But as you'll see Representative Shalala note, that's not necessarily how HIPAA works. So keep that in mind as you are working through COVID-19 information in the employment relationship. Now, we have maybe a minute for questions. So if you have anything, feel free to type it into the Q&A widget. As I don't see any questions, I'm going to start wrapping up today's program. Thank you all. On behalf of Mayor Brown and on behalf of my colleagues, we really appreciate your time and your joining us. I hope you found the program useful. Some final housekeeping items for today's participants. As Debbie mentioned, you will receive a recording of the program as well as a link to the materials from the program. Those will each be distributed by email to you in the next day or two. Thank you all for participating, and this concludes our webinar.